to the excellent observations that we'll hear from you and from the United Kingdom. As children spend drastically more time online, the tech platforms really have become a perilous minefield for many of them. They're deeply addictive and potentially destructive without sufficient parental supervision or safeguards. I've fought for data privacy rules for consumers and accountability for tech companies, focusing on the harms that they cause. Nowhere is that more profound and urgent than for children. Big tech and data brokers are spying on children, watching them play, monitoring their lives. No company should be allowed to collect permanent invasive dossiers on our children. Even more concerning are the cesspool of illicit pitches to kids. In a survey last week by the anti-human trafficking organization Thorn, the finding was that more than a quarter of children 9 to 11 years old receive sexual solicitations on social media, often by adults. A quarter of those children receive sexual solicitation. These children are also assailed by aggressive, sophisticated, undisclosed marketing that prey on their impressionable minds and exploit those dossiers of private information for commercial gain. Two examples, one TikTok, the other Instagram. According to Thorn, 66% of young children, 9 to 12 years old, use the video sharing app TikTok. It can often be informative and entertaining. It's held itself out to parents to be safe, but it has aggressively recruited young users. Regrettably, TikTok has a troubling track record on children's privacy. Only 2 years ago, TikTok paid a then record $5.7 million fine for disregarding our children's privacy rules and illegally collecting data about kids. It then shared this sensitive information with third parties and advertisers. This practice still continues. In March 2020, children's advocates, led by Professor Campbell, filed a complaint with the Federal Trade Commission alleging TikTok continues to violate the law. TikTok is also facing investigations in Europe for failing to protect children. Privacy is not the only issue. Organizations like the National Center on Sexual Exploitation and the Center for Digital Democracy have all raised concerns about predatory sexual content and manipulative advertising on TikTok. The FTC even called attention to TikTok being used by predators to groom nearby children in its case against the company. Because TikTok is so popular with young audiences, Ranking Member Blackburn and I invited the company to this hearing. We asked them to come in and explain how they're safeguarding children. Parents deserve to hear from TikTok, and I'm disappointed that TikTok rejected our invitation and refused to discuss these issues with Congress. We're going to continue to invite them to come. I hope that they will give parents and Congress the explanations we deserve. They've been failing to do it. I'm also alarmed by Facebook's recent announcement that it will launch a version of Instagram marketed to children. Instagram has a notorious record of disinformation, bullying, and deception. Prominent Instagram influencers often push alcohol, tobacco, and other dangerous products on young fans, despite warnings from the FTC. Sexual exploitation is also a problem. According to Thorn, 16% of children and teens that have been sexually harassed on Instagram tied with Snapchat for the most reports of harm. I have no trust, none, that Facebook will keep these young users safe. It has failed Far too often, for example, one design flaw in its Messenger Kids app allowed strangers to chat with children. Given that record, I cannot imagine why Facebook would bulldoze ahead into kids' lives. Senator Markey and I wrote to Facebook asking questions about its plans, and we have received woefully inadequate answers. I agree with the 44 state attorneys general and dozens of child welfare specialists saying, no, Facebook should abandon its plans for Instagram Kids. Facebook should stop this additional intrusive and potentially dangerous interference in kids' lives and abandon plans for Instagram Kids. As for the way forward, we must stop these business practices, corporate negligence, and commercial exploitation of children that now exists online. Spying and preying on children is never okay. Parents are powerless to prevent it now. They need the tools to stop it themselves, or Congress must intervene to end it. I commend my colleagues, Senators Markey and Cassidy, for introducing the bipartisan Children and Teens Online Privacy Protection Act. I've worked on this issue with them, and I will be strongly supporting and advocating such measures. But we need to do more. The Earn It Act that Senator Graham and I introduced last session, approved unanimously by the Senate Judiciary Committee, offers a template for even broader action on Section 230. Eventually, the tech platforms must be held accountable. They must bear liability for obvious violations of criminal and perhaps civil law, and the cutbacks in Section 230 immunity, carefully tailored to meet the needs of harm to children, offer a very important path forward. And I also commend the trailblazing work of Baroness Kidron to draft an age-appropriate design code and an online safety bill in the United Kingdom. It too offers a potential model for us. I now turn to Ranking Member Blackburn.
Thank you, Mr. Chairman, and I want to welcome our witnesses, Mr. Egelman, Ms. Campbell, who are with us in person, and Baroness Kidron, who is joining us remotely today. And to our staffs who have worked on this issue, I thank you for doing the work to put this hearing together. Mr. Chairman, I join you in being disappointed with how TikTok has refused to appear before us, and remain disappointed and really frustrated with them in their lack of attention to data security, to children's privacy, and it seems that TikTok is proving to be incapable of doing the right thing to protect our children. The internet has completely revolutionized how our society functions. Anything you could ever want or need can be found online. This has made the internet a logical tool for parents and teachers to help educate and entertain their children through online services and streaming platforms. Children born today will spend more time connected online than any other past generation. Companies use advanced data collecting techniques to gather and analyze the habits, movements, and interests to build out a virtual you that only exists to cater to advertisers. While I've spoken on this before, the impact this has on children can be even more detrimental. By taking advantage of the always-on mentality, children are constantly being tracked and analyzed. Take TikTok, for example. They have been accused of using algorithms to keep kids scrolling indefinitely. Alphabet, Google, and YouTube's parent company has been accused of tracking children when they aren't using their school devices and using features such as autoplay to keep kids glued to their devices. But this doesn't end with tracking and scrolling. Companies like Snapchat have exposed children to predators and explicit adult content while using their products. With millions of teen users, disappearing messages, and a map of all of your contacts, this has become a child predator's dream. Instagram, which Facebook owns, announced that they were going to create an Instagram for kids, but was immediately met with backlash from over 40 states, including Tennessee. As time moves forward, children will be at the forefront of technology, with each generation being more connected than the last. That is why it is so important that we get this right. We must ensure that children aren't being taken advantage of and molded into something that they are not. Social media is causing our children to become more distressed than ever before. Don't take my word for it. Go talk to any pediatrician. Companies exploit children's desire to connect with their peers, utilizing behavioral design tools that are highly addictive. Young girls, in particular, are susceptible to body image issues and decreased self-esteem from the distortions of reality present on many of these platforms. With so many children engaging in remote learning during this pandemic, it is more important that we remain vigilant as parents and grandparents. We must not forget to focus on protecting their virtual you as we work to craft comprehensive privacy legislation. Last Congress, Senators Wicker, Thune, Fisher, and I introduced the Safe Data Act, which contained a requirement that companies not transfer the data of individuals between the ages of 13 and 16 without the express consent of that individual or of their parent or guardian. I'm pleased to see continued engagement on this important topic, and I look forward to working with the members of this committee to craft legislation to help protect our precious children from big tech. Thank you, Mr. Chairman.
Thanks, Senator Blackburn. I don't know whether Senators Cantwell or Wicker have any comments remotely. I guess not. I'd like to now introduce the witnesses, and we are very pleased to have you here today. Professor Angela Campbell, Professor Emeritus at Georgetown Law School. Professor Campbell is the chair of the board of the Campaign for Commercial-Free Childhood. She's also Director Emeritus at Georgetown Law's Institute for Public Representation. She received her JD from the University of California, Los Angeles, and her BA from Hampshire College. Dr. Serge Egelman, Research Director of Usable Security and Privacy Group, International Computer Science Institute, University of California, Berkeley. Dr. Egelman leads the University of California's Berkeley Lab for Usable and Experimental Security, known as BLUES. His research focuses on the intersection of privacy, computer security, and human-computer interaction with the aim of better understanding how people make decisions surrounding their privacy and security, and then creating data-driven improvements to systems and interfaces. He received his PhD from Carnegie Mellon University and his BS from the University of Virginia. We're also joined remotely by Baroness Bevan Kidron, founder and chair, Five Rights Foundation. Baroness Kidron is the founder and chair of that organization, a foundation dedicated to making systematic changes to the digital world to ensure it caters for children and young people by design and default. She is a crossbench member of the House of Lords and sits on the Democracy and Digital Technologies Committee. She introduced the Age-Appropriate Design Code, the first standalone data protection regime for 18s into UK law. She also is a commissioner for UNESCO's Broadband Commission for Sustainable Development, where she is a member of the working group on child online safety. Thank you all for being here today. We will begin with testimony from Professor Professor Campbell.
I want to thank the Chairman Blumenthal, Ranking Member Blackburn, and the distinguished members of the subcommittee for inviting me here to testify about protecting children online. I am, as Senator Blumenthal said, the chairman of the board of the Campaign for Commercial Childhood, a leading watchdog of the children's media and marketing industries. Its advocacy is based on overwhelming evidence that child-targeted marketing and the excessive screen time that it encourages undermines kids' healthy development. CCFC led the charge in filing a complaint against YouTube for violating COPPA that eventually led to the FTC's 2019 settlement, which included a record fine of $170 million, and it limited the collection and targeting advertising on child-directed content on YouTube. Most recently, CCFC worked with a coalition of advocates and sent a letter to Facebook urging them to drop their plans to offer Instagram for kids. My testimony also draws on my over 30 years experience as directing this clinic at Georgetown, where we actually filed the very first complaint with the FTC ever about a website that was targeting children, alleging that they were engaging in unfair and deceptive practices. And after a lot of hard work by many people, including then Representative Ed Markey, Congress passed the Children's Online Privacy Protection Act, or COPPA. I'm extremely proud of this accomplishment, and I think it's provided significant protections for children, but it is badly in need of updating. In my written testimony, I address 3 issues. 2 of them I'll leave for the questions, that is why children and teens need more protection against unfair and deceptive advertising practices online, and also my suggestions about what the FTC could do to better protect children. So now I will focus on why COPPA needs updating and how it should be updated. When COPPA was adopted in 1998, there was no YouTube. There was no social media. There were no smartphones, no smart speakers, and no Internet of Things, including toys connected to the internet. At that time, children's use of screens primarily consisted of watching broadcast or cable television. But today, as you've noted, they use digital media for education, entertainment, and socializing, and they spend many hours a day using these devices. And this time, of course, has only increased with the pandemic. As children and teens shifted their viewing from television to digital devices, marketing also became digital and much more powerful. It uses incredibly sophisticated and elaborate systems to deliver targeted advertisements. The advertisers are able to track the users online across multiple devices, combine that data with other data from other sources, and use very powerful algorithms of machine learning to decide in real time what ads an individual will see. This system allows kids to be profiled, for example, as gamers or impulsive purchasers or anxious oversharers, and then targeted with ads designed to manipulate them to do more of those things. The dominant business model is for the platforms to keep the children engaged as long as possible, because in that way, they will see more ads and the platforms can collect even more data about them. This unregulated business model harms young people whose developing cognitive capabilities are no match for today's highly sophisticated digital marketing tactics. While it's profitable for the platforms, it means that young people are spending a lot of time online, and they're often viewing things that may not be appropriate for them, or as you mentioned, being solicited for inappropriate purposes. Time online has also been associated with a number of different problems, including depression and mental health, poor nutrition, insufficient sleep, problems in school, cyberbullying, online sexual abuse, risky behavior, and in some cases, even suicide. The COPPA rule that the FTC adopted and amended in 2013 generally prohibits targeting and profile of children under the age 13 unless parents have given notice about what data is collected, how it will be used, and with whom it will be shared, and have given advance verifiable consent. However, these protections only apply in two situations. First, where a website or online services is directed at children, and second, where the operator has actual knowledge that it's collecting data from a child. Now, it's difficult to know whether or not a service is directed to children. And of course, children don't limit themselves to using only services directed at children. They use sites that are directed to mixed audiences or general audiences as well. And so when they're doing that, they're not covered by the protections unless the company has actual knowledge. This actual knowledge standard is very problematic because it incentivizes operators to avoid complying with COPPA by not knowing or pretending not to know that children are using their platform. This is exactly what YouTube did until the FTC finally brought its enforcement action. Even though YouTube was and is the most popular online destination for children, Google insisted for years that YouTube had no COPPA obligations because its terms of service said the service was for 13 and above. Similarly, today, TikTok, terms of service says it's for only 13 and above, and yet it has internally classified 1/3 of its users as younger than 14, and this is true even though they're already subject to this consent decree with the Federal Trade Commission to make sure that they comply with COPPA. So I think part of the problem with actual knowledge is that it's really hard to prove. While in these two big cases, the FTC did conduct investigations and it did find actual knowledge, companies know that the FTC rarely initiates investigations. In fact, in 21 years, there have been 34 enforcement actions brought by the FTC. And it's very difficult to prove actual knowledge. It's a subjective standard which has to examine what the relevant people knew when. It's information that is not public, and there are many different parties involved in serving ads to kids, and many of these decisions are made by machines, by computers. So it's important to replace the objective standard with constructive knowledge, which essentially means that the operator knew or should have known. It imposes a duty of reasonable care on the operators to determine whether they are collecting data from children. And I'm very pleased that the Children's and Teens Online Privacy Protection Act, which was introduced by Senators Markey and Cassidy, would replace actual knowledge with constructive knowledge, and it also makes clear what that means in the context of the digital ecosystem. Now, the other big problem with COPPA is that it only applies protections to children under age 13. Once a child turns 13, he or she is treated just like they were an adult. But teens are not developmentally the same as adults. They're still developing their capacities for self-regulation. They're wired to seek approval from their peers, and they lack the experience and judgment to assess risks and understand long-term consequences. With teens spending on average 7.5 hours per day on social media, playing video games and watching videos, this means they're developing their social and personal identities online. And apart from the harms that I've already mentioned, this data can be used, the data collected from all of these activities can be used to affect their future opportunities, such as whether and where they go to college. The Children and Teens Online Privacy Protection Act, as well as the KIDS Act, which was introduced last session by Senators Markey and Blumenthal, would extend developmentally appropriate protections to minors defined as ages 13 to 15. It would allow operators to collect personal data from minors only if they adopt and follow a digital marketing bill of rights for minors that is consistent with the fair information practices set forth in the legislation. It would also prohibit targeted marketing to minors unless the minors were given sufficient notice and gave affirmative consent. So I see that my time is about out, and so I will leave the other areas that I want to talk about, which is the need to apply protections against unfair and deceptive advertising and other things that the FTC could do to the questions. Thank you, and I'm happy, look forward to answering your questions.
Thanks, Professor Campbell. I'm sure that you'll have an opportunity to go into those other areas. Mr. Egelman?
Chairman Blumenthal, Ranking Member Blackburn, and the distinguished members of this subcommittee. It's an honor to be here today. Thanks for inviting me. My name is Serge Egelman, and I direct the Usable Security and Privacy Group at the International Computer Science Institute, which is a research institute affiliated with UC Berkeley. I'm also the CTO and co-founder of AppCensus, which is a startup that does privacy analysis of mobile apps. As background, I've been studying consumer privacy online for almost 20 years now. And actually, over the past 10 years, my research group has focused on mobile apps. And in fact, 2 years ago, and likely the reason I was asked to testify today was because my lab published a paper where we studied children's apps specifically. And so what we did was we went to the Google Play Store and basically just downloaded as many kids' Android apps as we could. I'm picking on Android just because Android's open source, and so we had to write, pretty sophisticated instrumentation into the operating system itself so that we can monitor exactly what data apps try and access and then to whom they send it. Using this instrumentation, we ran almost 6,000 different apps, all, again, targeted at children, self-selected by the developers. When they post those apps into the app stores, it's the app developer who says, this is a child-directed app. Please list it in the kids category. And so given that, they should all be covered by COPPA. What we found was that more than half of them had indications that they were likely violating COPPA. So to give you some examples, about 5% of the apps that we looked at transmitted outright contact info like names, addresses, email addresses, and location data. So 1 in 20 apps, those are the types of cases that the FTC has successfully prosecuted in the past. 40% of the apps were transmitting other types of personal information, such as persistent identifiers, which are used, that's what enables all of this tracking. And I'm happy to go into details during questions about how persistent identifiers are used, if you want follow-up on that. Another 40% of the apps, these are non-mutually exclusive, basically rendered the user-controllable privacy settings useless. So on Android and iOS, both Apple and Google offer user-controllable settings where you can opt out of tracking. And the way that that works is that when the user chooses to opt out of tracking, what should happen is that the operating system prevents the apps from accessing the user-resettable identifiers, or it allows the user to reset those identifiers in much the same way that a user might clear their cookies from the web browser. The problem is, if they're collected alongside other identifiers, that basically renders that functionality useless. And so we saw that happening in about 40% of the cases. And then also, to be clear, most of these potential violations that we observed were due to third-party data transfers. So the apps themselves had all of these other components. It's very common in software engineering to have third-party components similar to other branches of engineering. So for instance, a car manufacturer usually doesn't make 100% of the parts in a car themselves. With software, developers will put prepackaged components in. And the problem comes when those components either are misconfigured by the developer to inadvertently enable tracking of children despite COPPA-compliant settings that the directors are instructed to use if the apps that those third-party components are bundled in are directed to kids. They're supposed to set these settings, and that wasn't happening. But also in 20% of the apps that we examined, they were sending data to third parties whose terms of service explicitly said, we don't knowingly receive data from children, and therefore please don't use our components in child-directed apps. Nonetheless, 1 in 5 apps appeared to be violating that, and you might wonder why the terms of service has this prohibition. That's because if you read the privacy policy, for most of these services, they make it pretty clear that the data that's being collected is going to be used for profiling purposes or behavioral ad targeting. We also found as many safe harbor certified apps as we could. So under COPPA, the FTC has blessed 7 organizations as safe harbor certifiers. And so an app developer or other online service provider can go to one of these 7 services, and once they submit their product and fill out a questionnaire, the certifier deems the app COPPA compliant, and that indemnifies them from FTC action. So looking at the safe harbor certified apps, we found that they weren't appreciably better in terms of COPPA compliance. And just looking at the raw numbers, they actually appeared to be worse. And that's actually, there's a lot of economics literature on adverse selection with these types of self-regulation programs, where it's the worst actors who have the incentives to participate. The actors who are already complying with the law, why would they pay money to get certified, to be, against enforcement actions? So based on this research, I have 4 recommendations for improving COPPA. So one is, the actual versus constructive knowledge standard, and Professor Campbell talked a lot about that. I can go into detail during questions about some of the issues there. The other problem is the internal operations exemption. So under COPPA, there's an exemption for collecting, again, the persistent identifiers that enable the tracking ecosystem if they're collected for internal operations purposes, which isn't actually defined by statute. In the statute, the FTC in the last round of rulemaking, I think that was in 2013, had added a bunch of categories. The problem is all of those categories under internal operations don't strictly require personal information, for those uses. And so that's why this exemption is kind of moot. Also for another reason, which is by policy on the major platforms, both Google and Apple, they require, Apple for kids apps doesn't allow developers to collect identifiers, period, for tracking purposes. And so there's no internal operations exemption that I'm aware of for the Apple platform if you're an iOS developer. Google has similar policies where collecting persistent identifiers from users requires consent in many cases. And again, that's why the internal operations exemption, based on my research, it seems to be abused a lot by app developers, partially because they probably don't understand what it means either. And so that's why I think that should be eliminated. The third and fourth thing are related, so increasing enforcement actions. I have some ideas there. The FTC does excellent work. There's some very smart people there that understand these issues. They're just overburdened. They have a lot of things on their plate. They get a lot of complaints to investigate, and they just don't have the resources to investigate them all. And so finally, in parallel with that, I have some ideas for fixing some of these safe harbor programs. One is that it's not clear what they actually do. So I think one regulatory update, or I guess something that the FTC could do through regulation, is set standards and have invited privacy experts to comment and on the proposed standards that those safe harbors should have to follow. But then 2, the other issue is my research team had a very hard time identifying what was and wasn't certified by any of these programs. Many of the apps that we looked at had privacy policies that said they're certified by these programs. Many of the certification organizations had the names of apps on their websites. When the paper was published, many of these organizations said, oh, they have no idea it's not actually certified by us, despite the name of the app still appearing on their website for months after making those public statements. And so there's clearly, I'm not going to go and say bad faith, but there's clearly a lot of consumer confusion here. And so I think one fix there is just mandating that every safe harbor organization should have to publicly post what apps are actually certified and what versions of those apps, because anytime the software is updated, the privacy behaviors could change, and it might, suddenly a software update occurs, and now the app is doing something that would violate COPPA, but it's been indemnified due to the safe harbor. And so that's a situation that I think needs to be addressed. And I'll leave it at that.
Thank you very much. Excellent. Baroness Kidman, I hope we have you remotely.
You do indeed, and thank you, Chairman Blumenthal and Ranking Member Blackburn, for inviting me to address this critical issue, and my apologies for not being with you in person. I think it's important to make explicit that while I'm a member of the House of Lords, I'm not a member of a political party nor the government, but I sit as a crossbench peer. This affords me the great privilege of working across both houses on a truly non-partisan basis. And I have authored and introduced legislation on this subject and participated in several committee inquiries. I am the co-founder and deputy chair of the All-Party Parliamentary Group for Digital Regulation and Responsibility. And outside Parliament, I chair the Five Rights Foundation, a charity that is dedicating to building the digital world young people deserve. In 2018, as part of the Data Protection Bill, I introduced an amendment to create the Age Appropriate Design Code. The AADC, or the Children's Code as it is fondly and commonly known, has some key features. The code defines a child as any person under the age of 18. This is in stark contrast with the tech sector that has exploited a gap in legislation to treat all 13-year-olds as adults, when any parent will tell you that their 13-year-old is not yet adult. Similarly, the code is applicable to services likely to be accessed by children, rather than restricting protections to services directed at children. Most children spend most of their time online on services which are primarily designed for adult use. The 15 provisions of the code offer a child a high bar of data protection, including protections from revealing their location, using a child's personal data to deliver detrimental material, or deliberately nudging them to give up their privacy. And as the September 2nd deadline for compliance approaches, the impact of this one small legislative effort is becoming apparent as companies have to redesign their services to better protect minors. In a recent conversation with one of the major platforms, I was told that all their product teams now have to consider not only the 15 provisions in total, but also really interrogate what its overarching requirement to process children's data in, I quote, the best interests of children. And if I might actually quote the code directly, it states, it is unlikely that the commercial interest of an organization will outweigh a child's right to privacy. These baseline protections are overwhelmingly popular with the public. That is, a public tired with industry norms that promote intrusive and addictive design practices or exacerbate and recommend harmful material. And they are frankly sickened by the idea that a child's real-time location can be tracked by a stranger or predator. 4 years ago, the UK government announced that they would make the UK the safest place to be online by introducing an online harms bill. Last week, they finally published the text of that bill as the Online Safety Bill. This change of title is an important reflection of the journey government officials have been on. It is now widely accepted we cannot argue over what is and isn't acceptable after gross harms have been committed, after children have suffered. We must consider their safety in advance. We cannot allow commercial interests to target a depressed or unhappy teenager on a Friday night with ads for inappropriate drugs, expose 9-year-olds to explicit interactions with adults, or push dangerous challenges to children through algorithmic recommendations. Just a month ago, a 12-year-old from Colorado died after taking part in a blackout challenge that was viral on a video sharing app. Mr. Chairman, I know you are a premier advocate for consumer education, and as I have worked on this issue around the world, gradually policymakers have come on board, but still parents, teachers, and very often children themselves feel helpless to understand how they are being manipulated. At Five Rights, we're about to launch a campaign to help bridge this gap. It's called Twisted Toys, and we have built a suite of toys that manifest in a palpable way how big tech is spying on and putting children at risk. This disturbing project graphically illustrates the urgent need for action, and I hope you'll be seeing a lot more about it in the next month or two. We do not accept this manipulation of children anywhere else. We must not accept it online. And the reason that parents, teachers, and children feel overwhelmed that this is because this is not a problem that parents, teachers, or kids can solve on their own. A system designed to extract every ounce of a child's attention, expose them to an infinite public, and encourages them to get lost in the mirror of anxiety is simply not healthy. The tech sector has the ability to raise the ceiling and give children back their childhood, but it is up to lawmakers to insist on the floor of behavior below which they must not go. And while the Children Code arguably makes UK's children online safety standards the highest in the world, it simply won't be good enough. The deficit in American standard setting on these issues is alarming. The US is home to the most influential tech companies in the world. We are doing what we can to protect our children, but we do need this administration, and we do hope you will act, because the norms you establish in the US impact on every connected child in the planet. And that is nearly 1 billion children and counting. I look forward to your questions.
Thank you very much, Baroness. We will now begin 5-minute rounds of questioning. I'll go to the ranking member after I finish, and then others on the committee. I think that the Baroness put it exactly right. These sites are extracting information, but also exploiting children, and parents can't protect their children alone. Senator Graham and I introduced the Earn It Act, which essentially enables parents to fight the sexual grooming, exploitation, trafficking, torture, and rape of children. It's a real and present danger. The statistic that 1/4 of all children are solicited on the internet for illicit sexual purposes is just absolutely alarming and astonishing. And the Earn It Act would create a narrow exception to Section 230 to empower survivors to stop the sharing of images and videos of their sexual abuse. It is a narrow, exceedingly targeted exception to Section 230. And the question is, for all the witnesses, shouldn't we broaden that kind of exemption so that the sites themselves, not just the exploiters, are held accountable? TikTok's failure to appear today, I think, is in some ways an admission that there are no adequate answers on its part to what is happening on that site. 66% of all children use TikTok. And the idea that it is extracting this information and then exploiting it, but giving others an opportunity to do so with the knowledge that it's happening, I think argues powerfully for modifications in Section 230, perhaps incorporating the age-appropriate design code that Baroness Kidman has championed so ably in the United Kingdom. Let me begin with you, Professor Campbell. Should we modify Section 230? I think you need your microphone.
We need to look at that question very carefully, because I agree that many operators are getting away with conduct that outside of online would not be permitted, and therefore, because they're immune or largely immune from prosecution, they have no incentive to stop. At the same time, obviously, it needs to be narrowly tailored. It would need to pay attention to chilling speech that is protected by the First Amendment, and also harming small businesses who really can't afford the kinds of litigation that might. But again, I do think that the idea is one that should be pursued.
Thank you. Mr. Edelman?
I think I need to think about that a little bit more. I think there are things that could be done without touching on some of the free speech issues associated with Section 230 that would potentially, do the same thing, such as, moving to the constructive knowledge standard and have other reporting requirements, to strengthen COPPA without necessarily touching that. But honestly, I think I would need to think a little bit more about that. I mean, my main concern is how that could, unintended consequences of that, so how that could be abused.
Baroness Kidman?
Thank you. I think I'm going to answer from the perspective of the code, because one of the things that has really troubled me is that we have concentrated on what we do once CSAM has happened, once children are being groomed. And I think that we have not considered enough safety by design. And what we really need to start seeing now is proper platform accountability about its design features. For example, introducing strange adults to children as a normal piece of design, or making children very, very public. And at the same time, promoting a culture of popularity and of revealing and so on. And I think there are a lot of things that we can do before we start on Section 230. What I would say is that the failure to keep companies accountable for what they recommend, for what they rank, for what they promote, is quite different from accountability for what you host.
Thank you. Would you agree, Professor Campbell, and I'll ask the same questions of the others, that Instagram should cancel its plans for Instagram Kids?
Yes.
Mr. Edelman?
Probably, yes. Yeah, I'll just leave it at that. I mean, I think the concern there is just that, I guess I won't leave it at that. The concern there, I think, is even if the Instagram Kids is, benign and isn't collecting all of the data from kids, it's another type of grooming behavior, right? It's locking them into the platform so that when they turn 13, all their friends are on Instagram. Now they're locked in and need to continue using it. And now it does start collecting all of their data. And then they're stuck making a choice. Do they abandon those social connections or, give up privacy?
Essentially, it grooms them, it prepares them, it extracts information, and it creates this web of involvement that is really perilous.
Yeah, exactly. And I think that one of the things that does come up a lot in the research, especially when looking at consumer perceptions about privacy, is this notion of learned helplessness, where, consumers just, understand that they don't know how to, tackle these privacy issues and have just sort of, gotten accustomed to giving away their privacy because they don't really feel that they have a choice.
Baroness Kidman?
I think, Chairman, Facebook have not earned our trust to start doing children's services in this way. I mean, and I think unless you have standards, unless you have agreement about what is a fitting platform for children, then of course they shouldn't go ahead and do this new platform. They cannot be trusted with children until we set out what that looks like.
Facebook has not only failed to earn our trust, it's actually betrayed our trust in many respects. And its practices with Messenger Kids, allowing strangers to chat with children, its other violations of trust certainly argue powerfully against now Instagram Kids. So I hope that it will cancel its plan. Ranking Member Blackburn.
Thank you, Mr. Chairman, and thank you to each of you for a very thoughtful discussion on this. I've been hard at work on what I call the virtual you protection agenda, which would be privacy, data security, some Section 230 reforms, tightening up the language there in Section 230, and then dealing with antitrust. And I think it's time we realize these are not companies that are in their infancy. They are full-grown companies, their valuations are high, and they are very intentional in the moves that they make. And Ms. Campbell, I appreciate your comments in regard to the intentionality of the moves that these companies are making with how they data mine and track and utilize that information. Baroness, I want to come to you first. You mentioned the contrast between the children's online age gaps in the U.S. compared to Europe. And in the U.S., where we don't consider an adult until you turn 18, but online, children 13 and 14 can easily get full access to certain applications without their parents' permission. And I think this really leaves them vulnerable. And we've mentioned Snapchat a couple of times. And in 2019, I wrote a letter to the CEO of Snap raising the concerns about how child predators were arrested talking to underage children through this app. This is just, as a grandmother, that is something that you just have to say, how in the world can they not find a way to tighten up this process? But you mentioned safety by design. So how do you think that raising the online adulthood age would change the way that companies approach children's privacy on their apps? And talk to me a little bit about how companies in the UK and Europe have adapted to the changes that you all have made.
Yes, thank you for that question. And I think both the chairman and you are speaking powerfully to the fact that the world of tech has transformed immeasurably, but the regulation hasn't kept up. And I don't think that the internet founders had in their mind that this was going to be the interlocutor of all childhood, and this habit, you know, taking the habits and thoughts and feelings of children and capturing them, you know, TikTok, Google, Facebook, Snap, and other unaccountable companies. And I think we should be worried that a child's latest selfie is stored for purposes yet to be decided in some server farm, whether that's in Hubei province in China or in Nevada, USA. So I think that we have a global issue here, which is, as you say, you know, a child of 13 is not an adult, and we must now extend our concern to children up until the age of 18. So adults, we can discuss differently, but children, we have a duty of care to, and we must fulfill that duty of care. To your point about the tech companies, I have a lot of conversations with engineers. And in fact, I always say that if I had £1 or indeed $1 for every time an engineer had said to me, I have never thought about it like that before, I could actually finance our foundation from one end of the year to another. What I mean by that is that we have to change our mindset. We have to think about what it means to be a child in that environment, and immediately in relation to the code, what they had to do is actually disband direct messaging for certain age groups. They're not they don't have the cognitive ability to work out whether that stranger is friend or foe. Just don't do it. And in the code, it actually says, do not use their data to offer them detrimental material. And that is, you know, don't use their browsing history. Don't use the fact they hovered over something to then to recommend it or rank it or put it into their feed. And so I think that it is actually easier than we think. What it is a commitment, is minimum standards, and it's a very, very clear enforcement path to say, this is what you must do. Not this is what you could do or do a bit better, but this is what you must do, because actually childhood is a precious state and children don't grow up to be good adults unless they have decent childhoods.
Thank you for that. Mr. Egelman, let me come to you, talking about this privacy by design, and you mentioned about how some of the companies use these personal identifiers and how these are used in concert with third-party data sets and algorithms to build more accurate profiles of our children, which is really a frightening thought when you look at the length of time that they can begin to gather that information and follow them. So talk to me a little bit about the safeguards that app developers could be using in order to protect the children's PII.
Yeah, that's a really good question. It actually hits on a few points you brought up earlier too. So one of the biggest problems I see right now with COPPA is that it shifts the compliance burden to lots of small developers who just really don't know what their obligations are, and then invariably, screw up by misconfiguring, some third-party component that ends up sending data, to advertisers or data aggregators. There are also, certainly there are also malicious actors who are intentionally doing that in children's apps, but the net result's the same thing, right? At the end of the day, there's some third party that's building dossiers of children, and whether the data was sent to them because, the app developer knew they were doing that and, because they get paid more to do it, or because something was just misconfigured. The app developers essentially have all the responsibility under the actual knowledge standard right now, because those third parties, just say, oh, well, we didn't know that this is children's data, and therefore we're not liable. And that's currently the state of the world. I disagree actually with something that Professor Campbell said earlier, which is that it's difficult to figure out when apps are child-directed. In many cases, it's not. So that information is public. Like in the Google Play Store, when you download apps, there are categories. And if the app's in the kids category, that means the developer actually went in there when they uploaded the app and clicked the button saying this is a child-directed app. And to their credit, Google has a pop-up that asks them if they're in compliance with COPPA, and of course they, click yes, and now their app is suddenly available in the Play Store. Anyone can actually just visit the Play Store or the Apple, the iOS App Store and see, whether a given app is in the children's category or not, and then use that information to realize that they're likely receiving data from children and take appropriate action, like delete it immediately and not do anything with it. But the fundamental problem is that they're receiving it. A lot of the issues here come from this, the failure to adhere to privacy by design principles. And so there's a whole framework called Privacy by Design that has several different principles. The most relevant here is data minimization. So data should only be, sent when absolutely necessary. In this case, this hits on the internal operations exemption. So there are all of these exemptions for which these persistent identifiers can be collected and then used for tracking purposes. But because there's ambiguity about what's considered internal operations, this data is being collected even though it's not strictly needed. So an example of that, one of the carve-outs is contextual advertising. So contextual advertising is in contrast to behavioral advertising, where you're not receiving ads based on your history of what websites and apps you've visited and played, but instead just what you're doing in the moment. So what's the name of the current app? In theory, the marketing company, is able to infer, given a user who uses this app, this is an appropriate ad to send them. So maybe like a real estate app, app is going to have ads for, real estate agents or something like that. The point is, though, if it's all contextual, which is allowed under COPPA, by definition, they don't need the persistent identifiers to figure out which individual user that is and create, a dossier about them. And so that's why, I think data minimization, would go a long way here.
Thank you. I know my time's probably up.
Thank you. We're going to go now to Senator Klobuchar.
Thank you very much. I want to thank you, Senator Blumenthal and Senator Blackburn, for having this hearing on such a timely hearing. We all know that more kids have been online during the pandemic, but we also know that years of hearing, trust me, from the social media platforms has not worked. So I guess I'll start with you, Ms. Campbell. In your testimony, you know 2018 filed with the FTC that ultimately led to the 2019 YouTube settlement. And I know you referenced it in your opening. Do you think those lapses, or do you think we should be doing for holding these companies accountable?
I'm sorry, Senator, I couldn't quite hear the last part of I heard you talking
Sure.
about
What
YouTube.
more do you think? I am talking about what more should be done to hold the companies accountable with the YouTube settlement. Yes.
Yes, okay. Yes, and this actually relates to what Professor Eagleman was talking about. Google, in the case of Google Play, does have this section called Designated for Families. And all of those ads, all of those apps that are available are supposed to comply with COPPA, and they're supposed to not have any inappropriate advertising. They're not supposed to have a deceptive and unfair advertising techniques. There's a number of actually quite good policies that Google has in place. The problem is that Google does not enforce them. And that's what his research showed, and much other research has showed. And that is why we also filed a complaint against Google Play, asking the FTC to investigate whether it was making misrepresentations or to the public about what it was doing. The FTC, this was filed in December 2018. The FTC did not take any action. We recently filed an update that cited some of this new research, and also the fact that there was a major class action suit that was settled and will require at least some of these third-party companies, which are mostly companies people have never heard of, like AppLoving and Unity and Vungle and things like that, would require them to really clean up their business somewhat. But I do think there's a lot more. I mean, it's not possible, even with all the resources in the world, for the FTC to go after every individual developer and every different programmer that's uploading videos to YouTube. And so therefore, I think the platforms need to be held accountable.
Agreed. So a report found, I guess it's for you, Mr. Engelman, a report found that more than 90% of U.S. parents believe that the Children's Online Privacy Protection Act, which only protects kids under 13, should be expanded to teens. Do you agree with expanding the protections?
Absolutely. I mean, I think adults should have the same protections, to opt out of this tracking when they, so choose. But yeah, no, I certainly think that the age should be increased.
Okay. We've been talking a lot about disinformation out there. Senator Lujan and I led a letter to the CEOs of Facebook and Twitter highlighting a report which found that approximately 65% of anti-vaccine content can be attributed to 12 individuals. We call them the disinformation dozen. Do you believe, and this can be for anyone on the panel, that the spread of misinformation online is particularly harmful for kids and teens, and not just about the vaccine, just misinformation in general? Baroness, if you want to take this, or anyone.
Yes, I would. And I think it's a really important point. And forgive me, because there's suddenly a hailstorm in the background if I sound a little funny. It is really quite crucial for children to trust and understand and grow to appreciate the nuance of information they're given. And they themselves repeatedly say that they are confused about what is true and what is false. And all the evidence points to the fact that they find it difficult to separate it out, and it is destabilizing. And I think that you're absolutely right to make the point that it is information, not only disinformation around health and so on that we saw in the pandemic, but actually they also report disinformation in terms of images about what they should look like, how they should behave, the truth that they are constantly presented with. And they find it very, very problematic. And we have a duty to do better by them as they grow up in a digital world.
Very well said. Thank you. Thank you, everyone.
Senator Markey.
Thank you, Mr. Chairman, very much. Thank you for having this very important hearing today. Thank you to Ranking Member Blackburn. Protecting kids online has been a priority of mine for a long time. And the COVID pandemic has actually made it even more clear. You know, the kids' use of this technology is just going through the roof. And it's exposing even more problems that have existed for the last 20 years in terms of kids' exposure to it. And it's why earlier this month I introduced with Senator Cassidy a bipartisan Children's and Teens Online Privacy Protection Act, which builds on the original COPPA law, the Child Online Privacy Protection Act, which I was the author of in 1998. This new COPPA 2.0 helps to protect kids up to the age of 16, 13, 14, 15-year-olds. The original law was just 12 and under, not adequate, not in this new world that we live in. And it would require consent in order to collect information from them. It would also prohibit websites and apps from collecting more data than they need to fulfill the service that the teen is requesting. The tech industry just loves getting all this information about children in our society. They just keep coming in on children, the tech industry, and gathering this information. The tech industry is just out of control on this issue. So from my perspective, do you agree that young teens are an especially vulnerable audience that deserves much higher levels of protection?
Yes, I do.
Do you agree with that, Mr.
Yeah, absolutely.
Engelman? Yeah, thank you. The legislation also includes a requirement that platforms should reasonably know that kids are on their websites and apps to get parental consent in order to collect children's data. After all, these companies have a lot of information about who is on their websites. Ms. Campbell, can you quickly explain why this constructive knowledge standard will help protect children's privacy by stopping websites from turning a blind eye to the fact that kids are on their platforms?
Thank you, Senator. Under the current law, operator is not responsible for complying with COPPA unless their service or website is directed at children, or if they have what is known as actual knowledge, which gives them the incentive to say, oh, we're not for kids, we don't have kids online, when in fact they do know, because they're collecting so much information from these kids that they can use this information and to determine age. And often, they also know because, well, TikTok, I don't know how they can say they don't, when they, there's so many articles about how kids are on the service. So yes, I do think that changing to constructive knowledge would make this a easier standard, both to apply and practice, but also for the companies themselves. I think it's a natural, it's like they knew or they should have known. It doesn't really depend on whether they actually knew what the algorithm was doing. And I think in Professor Eagleman's testimony, written testimony, he also addresses.
Yeah, thank you. And I know that you agree as well, Ms. Eagleman. So let me just say that I do think it's critical because of these tech firms and their exploitation of children. It's absolutely disgraceful what is going on. The tech industry just, you kick them in the heart, you're going to break your toe in terms of their relationship with children in our society. So I just think we need to add a constructive knowledge standard. That's critical to protect children. And I believe that the committee also should build on consent and disclosure requirements by enacting data use limitations. And one of those data use limitations should be outright ban on targeting advertising to children. Mr. Kidron, do you agree that Congress should prohibit online advertisers from using children's data to target ads to them?
Yes, I do. Before I answer your question, Senator Markey, can I pay tribute to the work that you have done for so many years on behalf of children and recognize that the world over, we know your name and the actions you've taken. So I just want to make that clear from here in London. Absolutely, targeted ads should be prohibited. Using children's data for that purpose is inappropriate. Contextual ads are perfectly adequate for the market, and I think that traditional communication law, both here in the UK and I believe in Congress, has already set out why it's unacceptable to bombard children with advertising. You know, childhood's a journey. Children do not have the cognitive capacity and life experience to understand the high arts of advertising and influence.
No, I appreciate that. Thank you so much. And Senator Blumenthal and I recently wrote a letter to Facebook CEO Mark Zuckerberg demanding answers about the social media company's plans for an Instagram plan to start bringing more children into their world. The company has yet to disclose all of the details of this plan, but it's clear that there are major risks to kids' privacy and well-being on this type of platform. Instagram for children sounds superficially very attractive, but we understand that it's a very vulnerable audience. Unfortunately, in its response to Senator Blumenthal and I, which I asked to be included in the record today.
Without objection.
Facebook refused to give Senator Blumenthal and I any meaningful commitments about how to ensure that its proposed Instagram Kids app does not harm young users' mental health and threaten their privacy. And that's why I am strongly urging Facebook to abandon its plans to launch a version of Instagram for kids. Ms. Campbell, do you share Senator Blumenthal and my concern about Facebook's proposal?
Yes, I do. I think it's already been discussed how they haven't earned our trust. They have a bad track record. I was one of the signatories of a letter that asked them to stop it. And I think given the way, since Instagram, there's already lots of kids on Instagram. They're already, it has some negative effects. And to open it up to even younger children is, I just think, a huge mistake and a big risk.
Yeah, I think that unfortunately, when it comes to putting children ahead of their profits, big tech always fails. That they forfeited the benefit of the doubt on this issue. It is time for this Congress to pass comprehensive privacy legislation to protect children. This goes on year after year after year after year, and we have to continue to wait and wait and wait and wait to put these protections on the books for children in our country. They are being targeted. They are vulnerable. We know it's happening. We can pass a law this year to protect these children. We should put it at the top of our tech agenda. Thank you, Mr. Chairman.
Thank you, Senator Markey, and I strongly share your view that Facebook's response to us was abysmally inadequate on Instagram Kids, failing to address our reservations and concerns, and I think the impatience with big tech's invasion of privacy and exploitive practices is now very broadly felt and bipartisan, as is indicated by the comments that have been made today. And they should be on notice that either they come to the table and participate in meaningful protection, or they will have failed to be part of this dialogue, and there should be action this session. Thank you.
Thank you, Mr. Chairman.
Senator Lee.
Thank you, Mr. Chairman. Thanks to all of you for being here today. This is such an important topic, and I share the passion that's been expressed by my colleagues on both sides of the aisle here. These are things that we need to address. In the past, there have been a handful of factors that have at times slowed progress, or in some cases even reversed it. Some of them are technical, others are constitutional. Sometimes the technical and the constitutional merge. As you're aware, in order to survive a First Amendment challenge, where the First Amendment is implicated, if you've got a government action that interferes with free speech, you've got to be able to survive strict scrutiny, which means that you've got to show that the government action at issue is directed at something as to which there is a compelling state interest. A compelling governmental interest must be the object of the legislation, and it must further that compelling state interest in the least intrusive, least restrictive means, through the least restrictive means possible. At times this has become a problem, as we learned in 1997 in a case called Reno versus ACLU. In that case, the Supreme Court of the United States invalidated provisions of the Communications Decency Act, provisions that would have prohibited the transmission of certain indecent content to minors. Now, in that case, as I recall, the Supreme Court concluded that the online harm and the risk of online harm to children was itself a compelling governmental interest, but that the provisions at issue didn't provide the least restrictive means to achieve that compelling state interest. Specifically, the court found that the age verification process for children at the time it simply wasn't viable and would potentially prohibit access of others who should not be prohibited from accessing such content. Now, that was back in 1997. 1997, I think, was the year I purchased my first cell phone, and it was a relatively decent phone at the time. It just made phone calls. It didn't do anything else, nothing else at all, and we were, of course, a decade away from anything resembling an iPhone. But since then, things have changed. So, Professor Campbell, in your view, has technology advanced sufficiently since 1997 such that age verification is now a reality in a way that it might not have been then? Could we overcome this hurdle now?
I can't really speak so much to technology. I do know that as part of this data collection that companies often will infer, or these advertising networks will be able to infer the age of the users, so that it may well be much, certainly it would be more possible today than it was in 1997. And also, there's just so many more kids online and everyone online using it for so many different purposes, so that in just so many ways that the world is completely different than it was in 1997.
From that, one could certainly argue that our ability today to use the least restrictive means of furthering a compelling state interest is significantly enhanced relative to what it was 24 years ago.
Yes, I think so, but I also want to point out that commercial speech, at least it's deceptive, is not permitted as to children. That does not, we with children are different than adults in that we as adults have some responsibility for their well-being, and so there's certain things that we would not permit to be regulated as to adults, we do permit to be regulated as to children.
Sure.
And so
once you enter into the territory of Central Hudson, then if it's deceptive, you may have other tools that will not themselves trigger strict scrutiny.
That's correct.
Now, online platforms gather a lot of data with regard to their users, understandably so. This is their business. They want to understand. They want to make sense of the marketplace in order to facilitate targeted advertising. That's how many, if not most of them, make a living. But I am concerned about what that can mean at times with respect to children and how they target children and what they're doing or not doing to protect children. Baroness Kidron, do online companies know, or if they don't know, should they know? Should they be expected and required to know the age of the minors who have profiles on their respective platforms?
Yes, Senator. I think if I could just point at something that happened a couple of weeks ago in Australia, where researchers asked to find 13 to 17-year-olds with an interest in alcohol, smoking, gambling, extreme weight loss, fast foods, online dating services. Those were 13 to 17-year-olds. And they were then able to fabricate ads mentioning prizes, cocktails, and asking them if they were summer ready. You see how insidious it is. So it's not even just should they know, could they know, to which it is an unequivocal yes. It's even when they do know, they're not treating them properly. And if I might also just say narrowly to your point that you just asked previously, is Five Rights recently wrote a report about age assurance. How do they know how old we are? And I have sent it to the committee. And I think what is absolutely true, and your observation is very sophisticated. It is indeed the case that things have changed. We do have technology. What we don't have is governance, transparency, and an agreement about what age assurance should be, how it should be properly deployed. So I think the answer to both your questions is, you know, we do have the means, we don't yet have the will.
Mr. Chairman, I realize my time's expired. Could I ask one follow-up question that leads naturally? Thank you very much. Baroness, I'd like to go back to you for a moment and follow up on an observation you just made. I've learned a lot about this from a number of experts in the field, and especially my friend Melissa McKay from Utah, who's done a lot of work educating parents and children about the risks associated with content. It can be obtained online, very often through social media platforms by children. Sometimes the content is delivered to them with full knowledge of how old they are, because of the fact that when they open an account, they're required to provide certain information about their age. And even with that, sometimes one could argue because of that, they receive awful content delivered to them, knowing what they have. And yet, these apps, these social media platforms often operate through apps that are themselves subject to app age appropriateness ratings on the Google App Store and also on the Apple App Store. And in many instances, these age appropriateness app ratings on the app stores indicate that the apps themselves are suitable for children, in other cases for teenagers, including young teenagers. So why is there such a disparity sometimes between the app's listed age appropriateness rating and the content available on that platform, and sometimes sent to a minor, to a child on that platform? Why the disparity?
Yeah, I mean, well, I think you maybe needed to ask TikTok if only they would show. No, I think the truth is, in fact, I should revise that and say Google and Apple. I have raised this question in Parliament. I have raised it more than once, and I think it is extraordinary that we do not have a regulation or a law that says the App Store must give the same age rating as the terms and conditions. But in fact, we go on consistently and find many apps that are labeled one thing, 9, 10, you know, very young ages, that then turn out to be 16 and 18. And it is something I will be turning my attention to, and I hope it's something the committee will turn its attention to. I think the other thing that I would like to say to you is that recently we did some research. Again, we'll be publishing it shortly, but it was the case that we could see a child being targeted with actually government safety information, but that same child was being targeted with self-harm material. In one case, very aggressive adult pornography. and so on. And I think this point that I'm trying to make is, yes, we can find out their children, and there are new ways of looking at age assurance that are data light and do not interfere with other users. But also, we have to extend and put in protections for those users that they know are children. I mean, this is just essential.
Thank you, Baroness. Really appreciate that, and I would love to work with you in that effort. Thank you, Mr. Chairman.
Thanks, Senator Lee. Senator Lujan.
Thank you, Chairman Blumenthal, and thank you to you and to Ranking Member Blackburn for addressing this urgent subject. Child safety online is a pressing issue in New Mexico. My home state is currently pursuing multiple court cases to hold companies accountable when they violate child privacy laws. I'm grateful for New Mexico's leadership in protecting the safety and privacy of young children online. Ms. Campbell, in one of these cases, Google is accused of improperly collecting students' physical location, browsing history, search history, contacts, and even voice recordings through its educational products. Google is used in over half of American public schools for its free products, and I do not believe that parents should have to choose between their child's privacy and their education. Ms. Campbell, yes or no, do you believe collecting data for advertising purposes is ever appropriate in the classroom?
No, it is not.
Dr. Eggleman, I know you've worked closely on one of those New Mexico cases. In fact, your lab was among the first to publicly report violations by Tiny Lab Productions to Google. In that case, Google first reviewed the app under question when it was submitted to its Designed for Families. That's a program that they have. And again, after you alerted the company, still Google didn't immediately classify the game as being primarily directed to children, despite clear advertising that the game was for kids and would keep them entertained for hours. And those are all quotes, keep them entertained for hours, right from Google, for kids, primarily directed to children. Google eventually changed course, but it took months for it to terminate the developer. By that time, the app had already been downloaded millions of times. Yes or no, to ensure that these apps don't take advantage of children, should Google reform its app review process?
Absolutely, yes.
And what recommendations do you have there, Mr. Eggleman, for reform?
I think one of the biggest problems is that there isn't really a review process. So Google has policies that they post that, developers are supposed to abide by, including, checklists that developers check to say my app is in compliance with COPPA. And that's pretty much the end of it. And so I think that, there should be some proactive auditing of apps. And actually, to their credit, it looks like Google is starting to shift in that way. I don't know if you saw their announcement. So it was a week or two ago where they're now following Apple's lead with the privacy nutrition labels. And if I remember correctly, I think one of the things that they had mentioned in that statement about that program that they're going to be starting was just that they might start including certifications from third parties that have done privacy audits on apps. And so I think that would absolutely be a step in the right direction. I think that honestly, I think that this is an opportunity to actually have, to create some robust competition around this by having, private entities that have rigorous standards that are, public and maybe regulated by the FTC. Because frankly, I think if Google did say that, they're changing their internal review processes, most people probably just wouldn't believe them. And it would be hard to tell as an outsider what exactly they're doing. And so I think that's why, outside forces are necessary here.
Appreciate that. Ms. Campbell, in your 2019 testimony to Congress, you reported that the FTC had no formal process for parents to file complaints or obtain relief for COPPA violations. What's more, of the 14 requests you filed to the FTC to investigate COPPA violations, none had been responded to. Two questions. Has any of that changed? And what can parents do when they suspect their child's data is being illegally collected?
Well, there's still no formal process of complaints. There's maybe some indication that the FTC is looking at these questions a little more And they did issue these 6B investigative demands so that they could understand better what's going on in the marketplace and what's happening to children. So I think that's a positive step. But I think parents should complain. Just because there's no complaint form you need to fill out doesn't mean you shouldn't complain. You should definitely let them know what's happening and what your concerns are. And they can also get in touch with groups like Campaign for Commercial-Free Childhood and other groups that are working to try to get the government to be more responsive to protecting children.
Thank you. And Mr. Chairman, I do have some other questions, but I'll submit them into the record for response as well. And I just want to thank all the witnesses for their time today and the work that they're doing and their commitment to protecting children as well. With that, Mr. Chairman, I yield back. Thank you.
Thank you, Senator Lujan. I have just a few more questions, and then if the ranking member has some, I'll call on her. Dr. Agelman, last August, App Census, a research firm that you have helped to lead, discovered that women's health app Premon was sharing deeply sensitive health information with Chinese advertisers. Senator Klobuchar and I and a few other colleagues sent a letter to the FTC urging it to investigate Premon. We're concerned that it's a privacy threat and a national security risk. These app stores are essentially the Wild West. Consumers have no way of knowing whether an app is child safe or secretly selling data to Chinese data brokers. I would also mention my continued concerns about TikTok's deep links with China, as well as the FTC's deception case in 2020 against a subsidiary of the Chinese firm Tencent. I suspect that a lot of these children's apps and digitally connected toys have substantial issues with sharing data to Chinese firms. From your research, how extensive is the problem of children's app developers sharing kids' personal data with Chinese firms?
That was actually how we started this line of research. That's a prescient question. This whole thing with the children's apps specifically, as I said, my lab has been building instrumentation so that we can monitor mobile apps to see what they do. And in the course of that, we started, playing with some kids' apps because there's law in that area that should be governing them. But one of the first ones we found was an app, I think, targeted at like 5 and under in the Google Play Store that, had several trackers going to Chinese companies. And then that's when we started digging deeper and found that this is relatively pervasive. The Premon finding that you mentioned was actually pretty insidious because the way that they're transferring the data is likely to not be detected by most people examining the app. And so, it's hard to tell in this particular case, and probably many other cases where apps are sending data to many of these third parties because, again, it's on given how obfuscated these transmissions were, it's possible that app developers just have no idea that their apps are doing this, and I think that's part of the problem here is that the app developers, I started to allude to this earlier, but I guess I didn't finish that thought, which is just that the compliance burden is put on the individual app developers, and there are, millions of them, right? There are millions of apps, but most of the concerning uses of the data here are going to data aggregators and advertising companies, and there are comparatively fewer of those. And they're the ones who actually, control the data and, have the ability to use it for, these harmful things. And so, that's one advantage of switching to the constructive knowledge standard, which is that shifts the compliance burden to those third parties substantially, and they're in the best position to actually do the enforcement here to shut off those data flows, and if they don't, then action should be taken against them because they know what apps are sending them the data, even if the app developers don't know that the data is being sent to them.
Well, who would those third parties be?
The makers of third-party components like, Facebook has components in, I might need to correct this exact number, but it's on the order of like 30 to 40% of the apps that we've looked at have Facebook code in them, which gives them the ability to send data to Facebook. Facebook's SDK, software development kit, is the pre-made component that developers download and stick in their apps.
So you would shift the burden.
Yeah, it would shift the burden to organizations like
They
Facebook.
have not only the visibility,
Yep,
but also the resources.
exactly.
And they have the resources to compensate women whose data is shared without their knowledge and consent, violating their privacy, potentially leading to exploitation of them for harms that are done, correct?
Yeah,
So they should be held accountable. Facebook.
absolutely. And all of the other, Facebook, Facebook's big and they have user-facing services, but there are also, lots of these companies that most consumers have never heard of before that are also collecting, large amounts of data from children and adults, often without the consumer's knowledge, and also often without the app developer's knowledge, because they might have misconfigured something, or it's just really obfuscated and intentionally trying to deceive the app developer.
And we can't depend on the FTC to do it alone.
No, this is the big problem is, again, the FTC does a lot of really good work and they have knowledgeable people, but they bring less than 2 cases a year because they just don't have the resources. Unless we're going to entertain giving them...
Even if we give them the resources.
Right. Well, even if you entertain giving them like a DoD style, sized budget, I still don't think the problem is going to be fully, under control. I think that, there are a lot of different facets here, and, these are complicated problems.
So we ought to give the FTC more resources.
Yeah, absolutely.
That's a thumbs up.
Yes, absolutely.
But even with those additional resources, we need other means of holding Facebook and the tech platforms accountable.
Yeah, because right now, without the resources to, bring cases, it's essentially an unfunded mandate.
Exactly. Let me ask you, Professor Campbell, about influencer guidelines. I know you've done a lot of work on this issue. The FTC released guidelines for online influencers. You know how pervasive their impact can be on kids. But these guidelines fail to sufficiently address the advertising that's targeted to children, nor are they fully enforced. Numerous unboxing videos on YouTube are, in actuality, people paid to promote toys, games, and other products to unsuspecting children. I'm encouraged by the FTC's request for comments on its endorsement guidelines, but I think a lot more has to be done. And I've repeatedly raised my concerns to the FTC that these influencers are manipulating and targeting children and often pushing dangerous products. Tell me what you think need to be made in the FTC's influencer guidelines.
Yeah, I agree with you. In my testimony, I talk about how on YouTube, 3 of the top 5 channels viewed in the U.S. are targeted at children, and they feature child influencers. And so these kids make lots of money. Not all kids make lots of money, but these, the top ones really make a lot of money. And sometimes they're promoting, sugary cereals or candy, and other times they're promoting toys. That's what a lot of the unboxing videos are about. Or even promoting their own line of products, as in the case with, I think her name is Diana, that I included a picture in my testimony where it's a 10-minute video, and then she becomes a doll herself that you can then buy online. So it's a big problem. And the FTC, the problem is, one is largely enforcement. This is a huge business, and the FTC just is not enforcing its guidelines as it is. But the other thing is when they do, and they haven't brought any cases involving children, programming directed at children, when they do bring cases, They merely require that the sponsorship be disclosed. And that's problematic for kids because, well, first of all, you can hardly see the sponsorship identifications if they're even there, especially when you're looking at like TikTok, where there's like 25 different hashtags and one will say hashtag ad. But they also just don't really understand that the purpose of these videos is to sell products. I mean, for little children, they think that Aventube and Brian and Diana are their friends, and they enter into what's called a parasocial relationship with these actual children, child celebrities, as well as spokes characters, cartoon celebrities that are popular with children. And so they really cannot, they just don't have the cognitive capacity to defend against that, even if they're told it's advertising. Of course, a lot of them can't read either. So I think what the commission needs to clearly recognize that and say, for kids that don't have this capacity, you just can't have this kind of programming. It's not enough just to disclose it.
Thank you. You know, I think that parents often are unaware of the impacts of this kind of manipulative advertising on children. Last week, the Center for Digital Democracy released a report describing how big tech is helping to fuel the childhood obesity crisis. Junk food, e-cigarettes, vaping, they've all been pushed to children, targeted to them. Tech platforms are harvesting troves of information that enable targeting of children by companies that produce these products. It isn't just junk food. In fact, the e-cigarette company Juul bought ads across sites like Cartoon Network and 17 magazine to target young audiences. This innovative and absolutely reckless tracking and targeting of children is a real public health menace. How is it that data collected from kids' apps is fueling these sophisticated ad campaigns and profiling to push these harmful products?
Well, I think one of the biggest problems is that the whole process of collection and how the data is used is not transparent at all, and it's very complicated, and most people don't understand it, myself including. I say I don't fully understand it, but I do know that if you don't know what's happening, and then as a parent, if your child's using their tablet or their computer for schoolwork or a phone, they're not seeing what the child is seeing, and yet there's so they don't know about it, and of course they haven't been asked. When we were looking at the apps on the Google Play Store that were in the Design for Families program, we found that a lot of them had advertising for things like gambling, for alcohol, and also just things that really were not appropriate for children. So I think, did I answer your question?
You did. Both of you have filed substantive complaints to the FTC about violations of COPPA. As you observed, I think, Mr. Egelman, in the last 21 years, only 34 COPPA cases have been filed by the FTC. That's plainly a lack of enforcement. It may be due to lack of resources, but it also may be due to lack of will or vigor in some administration. And my hope is that we will see an end to what you have called rampant non-compliance. I would call it the Wild West. And like the Wild West, it is increasingly perilous to kids, and my hope is that the FTC will be a stronger and more vigorous partner in enforcement going forward. I want to thank all of the panel. Thank you, Baroness. Thank you to both of you present here today. This has been a very valuable session, and on behalf of my colleagues, we express our gratitude to you and keep up the good work. Thank you. This record will remain open for a week. A number of colleagues have indicated they want to submit additional questions, and for now, it is closed. Thank you.